One LinkedIn post announcing your fundraise could cost your startup 2 crore rupees. That isn't a scare tactic. It's a legal reality that thousands of Indian founders are unknowingly walking into right now. Let's be blunt. The concept of equity crowdfunding, as you see it in the US or Europe, is a ghost in the Indian legal system for early stage private companies. Chasing this ghost, fueled by global headlines, is the fastest way to invite a crippling penalty from the registrar of companies. The stories promise a revolution. The reality is a minefield. Founders with the best intentions are making illegal public offers. They're exceeding investor limits and using public platforms to solicit funds, triggering violations they don't even know exist, and the consequences aren't trivial. We're talking about penalties that can reach 2 crore rupees or the entire amount you raised, whichever is higher, plus a mandatory refund to every single investor. The infamous Sahara case wasn't an isolated incident. It was a lesson written in giant letters that most of the startup ecosystem is choosing to ignore, and regulators are watching. They are actively penalizing companies for breaking these rules. The standard advice you get is useless. It tells you what the laws are, Section 42 of the Companies Act, CB regulations, but it gives you no strategy to navigate them. It's like being handed a rule book for a game you've already started playing with no idea of the score. You don't need a law textbook, you need a battle plan. The core of the problem lies in a fundamental misunderstanding. Founders believe they are conducting a private round when their actions are screaming public. You send out a blast email to a list of 500 potential investors. You think you're being efficient. The law sees an illegal public offer, even if only 10 people reply. Why? Because the limit isn't on who invests, it's on who you ask. You post on your personal LinkedIn, exciting news, we're raising capital to scale. Reach out to learn more. You think you're networking. The law sees illegal public advertising, period. You collect money via a simple bank transfer promising shares later. You think you're being agile. The law sees a violation of strict procedural requirements. The PAS-4 offer letter, the PAS-5 record, the PAS-3 filing. Failure isn't just a slap on the wrist. It's the startup killer. This is the danger zone, where your ambition outpaces your legal structure. And this is where most promising ventures die, not from a lack of vision, but from a lack of process. But what if there was a map, a clear strategic framework that aligns your fundraising actions with your company's stage of maturity? This is that plan. We call it the Capital Stack Maturity Framework. Understanding this isn't just good governance, it's a strategic weapon. It's a 4-stage system that provides the precise legal rails you must stay on. Your journey from an idea to a funded company follows this path. Mismatching your actions to your stage is where the disaster begins. Let's break it down. Stage 1, the trust circle. This is your genesis. You're raising a modest amount, perhaps 5 lakhs to 25 lakhs, from your inner circle, parents, uncles, former colleagues who believe in you more than the idea. The legal reality here is simpler, based on trust and straightforward agreements. This is often structured as a director's loan or through compulsorily convertible preference shares, or CCPS. But here's the trap. Don't let informal mean unprofessional. A WhatsApp message is not a contract. You need a basic written agreement. The biggest mistake is thinking this stage can scale. Trying to bring 50 friends of friends into this circle is how you accidentally trigger the alarms of stage 2. Stage 2, the smart circle. This is the danger zone. You have a prototype, some early traction. You need to raise a seed round, anywhere from 50 lakhs to 7 crores. This is the most legally perilous stage for an Indian startup. Your mission here is to master the private placement under Section 42 of the Companies Act. This is not a suggestion, it's a command. The rules are rigid. First, the 200-person limit. You cannot offer securities to more than 200 identified persons in a financial year. Remember, this is about the offer, not the acceptance. Second, no public advertising. Period. Any post on a public forum, any unrestricted website, it's a violation. The offer must be private through direct individual communication. Third, the process is non-negotiable. You must maintain a record of the people you approach in Form PAS 5. You issue a private placement offer letter in Form PAS 4, and you file a return of allotment with the ROCE in Form PAS 3 within 15 days. Get this wrong and you face that 2 crore rupee penalty. This is the firewall you must build around your company. Stage 3, the regulated crowd round. You found product market fit and you're scaling. You're looking at a Series A, raising 15 crore rupees or more. You've outgrown the limits of the smart circle. Your crowd must now be professional and regulated. Here, you engage with formal SEBI regulated entities like venture capital funds and alternative investment funds. They are the professional crowd. The legal process is intense, involving rigorous due diligence and extensive shareholder agreements. The other path is through SME platforms like BSE Startup or NSE Emerge. This is the closest India gets to legal equity crowdfunding for growing companies. It's a mini IPO, a public offer on a regulated platform built specifically for this purpose. Stage 4, the public market. This is the ultimate goal for many, an initial public offering on the main board of the BSE or NSE. This is the domain of SEBI's most stringent regulations. It requires a draft red herring prospectus, immense public scrutiny, and the absolute highest level of corporate governance. This is the only stage where you can legally appeal to the entire Indian retail investing public. The trust circle, the smart circle, the regulated crowd, the public market. The path to funding is not a random walk. It's a structured ascent through these 4 stages. Using a stage 4 tactic, a public appeal, at stage 2 is the fundamental error that can destroy your company. The law isn't your enemy. It's the rule book for the game you're playing, and mastering it is how you win. You now understand the framework. The question is, do you know with 100% certainty which stage you're in? And more importantly, are your actions fully compliant with its rules? Guessing is not a strategy. Waiting for a notice from the registrar of companies is a nightmare. Your seed round could be a ticking time bomb. That friendly angel investor agreement could have a fatal flaw. You need to move from uncertainty to clarity right now. That's why we built the private placement compliance scorecard and red flag detector. This isn't just another checklist, it's an interactive diagnostic tool. In less than 15 minutes, you will answer a series of strategic questions about your current or planned fundraise. It will analyze your process against the rigid requirements of Section 42 and instantly give you a compliance risk score. You'll get a personalized red flag report identifying the exact areas where you're exposed, from your offer process to your documentation, and a clear what next protocol to secure your company. Stop guessing. Start strategizing. Protect your vision, your company, and your investors. Click the link in the description below to get your instant compliance score and action plan. It's your first and most critical line of defense.